Hello, how are you? I am Professor Flávio de Leão Bastos Pereira, and this is Rectoratio, an international law channel. Well, today I'd like to talk about a little more about genocide and one specific issue of this important subject, the intention, the specific intention as an element of the crime of genocide. The crime of genocide is considered the crime of crimes, the most serious crime that can be committed against a human group. In fact, it deals with one of the four international crimes, in addition to war crimes, crimes against humanity, and the crime of aggression, which are distinguished from common or ordinary crimes by their extreme gravity. In fact, it must be considered that the four international crimes are normally interpreted in relation to the context in which they are committed. Thus, for example, war crimes are so considered when carried out during and in connection with an armed conflict, whether national or international, as we now can see with the Ukraine war, or even if you think about the Bosnian War. Another example concerns to crimes against humanity, since it is considered the conduct of a systematic and widespread attack against the civilian population. The perpetrator must be aware of such a systematic attack. International crimes are distinguished from ordinary or non-international crimes, as they are regarded as the most serious crimes concerning the international community as a whole, as expressed by the Rome Statute, for example. The appeals chamber of the International Criminal Tribunal for the former Yugoslavia also presented its qualification for such international crimes by using the expression universally condemned offenses in the case prosecutor against Nikolic. However, in relation to the crime of genocide, as analyzed by experts such as Professor William Schabas, for example, a different criterion was used that did not prioritize the need to know the context in which the international crime must be committed. While a clear notion of the existence of an armed conflict is required, for example, for the classification of war crimes, or even the knowledge of the existence of diffuse and systematic attacks against the civilian population in the hypothesis of crimes against humanity, the legal classification on the crime of genocide focuses primarily on the subjective element, that is, on the specific intention of the agent to make a human group disappear for religious, national, ethnic, or racial reasons, in whole or in part. Thus, as we can read in the Article 2 of the Convention for the Prevention and Punishment of the Crime of Genocide from 1948, genocide means any of the following acts committed with intent to destroy, in whole or in part, a national, ethnic, or racial or religious group as such, killing members of the group, causing serious bodily or mental harm to members of the group, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, imposing measures intended to prevent birth within the group, firstly transferring children from the group to another group. As can easily be seen from a careful reading, this article I've just mentioned from the beginning does not present a factual context that should prevail for the configuration of the crime of genocide, but only the motivations and the intent of the perpetrator, the intent to destroy. the requirement of the international element, specific intent, is considered by Professor William Schabas in his work, in his book, Genocide in International Law, as counterproductive, since the crime of genocide is, per excellence, a crime that still presupposes an organization or an official state planning to exterminate a group. The author states that the crime of genocide is the archetype of a state crime, even though private individuals can commit it too. In the genocide case, the trial chamber of the Yugoslavia tribunal acquitted the accused of complicity in committing genocide, as it had not been clearly proven that the other alleged complicity had also committed genocide. In the same case, the appeals chamber recorded its opinion that the existence of a plan or of a policy does not necessarily constitute an element of the crime of genocide. However, in order to prove the specific intent, the existence of a plan or a policy of extermination can be considered an important factor in many cases, provided that the evidence is consistent with eventual plans by the state to commit genocide. The subjective element generates many problems and criticisms in the face of concrete cases. Still in relation to the debate on the intentional element for the configuration of the crime of genocide, the Brazilian judge of the International Court of Justice, Antônio Augusto Cansado Trindade, in the Croatia case against Serbia from 1215, in his explanation of vote, presented an interesting perspective in understanding the circumstances of the specific case, as well as the intensity of the violence revealed by the perpetrator that can serve as evidence of the genocidal intention by the perpetrator. Well, we will come back to this issue in the next videos. We'll come back to this topic again. Thank you very much. And if you liked this video, please share it. Thank you very much.